welcome to the Roberts Law Office Injury Podcast. Kentucky attorney Jeff Roberts has over 25 years of experience. He'll provide answers to your questions related to personal injury and automobile accidents, workers' compensation claims, and Social Security disability benefits. Let's join Jeff for this episode. And welcome back to the podcast. We're in Calloway County with Social Security disability attorney Jeff Roberts. Jeff, how are you this morning?
Doing good, Jim. How are you?
Buddy, I'm doing well. So today we're going to jump into a question that you may have heard before. It's, do I have to appear for my Social Security hearing? And, you know, there are a number of different ways that people can participate in these hearings, but this is really, if you want to back us up and give us some context here, the hearing is really kind of further down the road, right? That is their kind of day in court, if you will. But a lot of stuff has to happen before we get to that point, correct?
True. Most people don't realize that the hearing is actually the third step in the process. You make the initial application. Statistically speaking, you're going to be denied at the initial application. You file a request for reconsideration. Statistically, again, you're going to be denied at the request for reconsideration. Both of those are strictly paper decisions. They look at the medical records. They look at what you submitted, but you don't really testify under oath. You do fill out paperwork that they will look at and take into consideration, but you don't testify. The decision's not being made by a judge. After the request for reconsideration decision, if that is a denial, then you can file a request for a hearing in front of an administrative law judge, and that's actually the first time the case gets in front of a judge, and that's the level where you get to testify on your Social Security disability application or SSI disability application. You get to testify and explain to the judge why you feel that you are disabled in that regard. So,
and friends, if you've listened to these podcasts for a while, in fact, this is episode 109, so we've been doing this for quite a while. I like to reference previous episodes to try to give you a little bit more context. If you want to go back to episode 92, we actually walked you through the entire process for applying to Social Security disability, and a lot of the paperwork, a lot of the forms, and a lot of the overall process that Jeff just described. We actually spent about 30 minutes in depth talking about how that rolls out and what you might be able to expect. Jeff, let me ask you this. You said statistically that initial application is generally going to be denied, and maybe that's a way of just making sure that the people that really need it, you know, keep coming back, and so they can kind of winnow down those numbers of applicants. I don't know why that is, but like you've said before, that initial application probably isn't going anywhere.
Most likely it's not. The ones who are granted at the initial level, usually it's because of the severity of their medical condition. You know, they've got, chronic kidney disease and on dialysis or things of that nature. Those are the ones that are granted at the initial level. And, you know, I have people call me up frequently about a Social Security claim when they've not yet filed for disability. I generally tell people that if you're capable of doing so, sometimes people don't have the ability to do that, to make the application themselves, but I normally advise people to make the application themselves and then reach out to an attorney after they get that first denial. The reason for that is statistically you're going to get denied, but if you happen to be one of the very few that are granted, in my opinion, there's nothing that myself or any other attorney is doing to cause it to be granted at the initial level. And there's no sense in paying an attorney fee when you can come in after the initial decision, the initial denial, come in and hire me or an attorney at that point in time. I think there are a few attorneys that want to wait until after the second denial before they get involved. I like to get involved after the first one, not because I think I'm going to cause it to be granted at the second level. Sometimes I am able to do so. I certainly think that my being involved at the second level has a better chance of it being granted, depending on what we get from the doctors. But I like to get involved at that level so that when we do get to the hearing level, which I anticipate we're going to, I've already got all my ducks in a row and I'm ready to go to a hearing as soon as possible in that case, and I don't have to ask the judge for any kind of continuance or postponement because I'm waiting on information to come in from the doctors for us to be successful. Sometimes it takes quite a while to get forms filled out by doctors to get the medical records and things of that nature. So if I have a couple extra months lead time on doing that, then I think it works out better for the clients because I don't have to postpone anything at that point. So
That makes sense. And you had mentioned there are some situations in which, you may actually get approved earlier in the process. And back in episode 76, we did go through the listing of impairments for Social Security disability claims. And there were a number of them. And you went in detail and gave some really good examples in there. So
Right.
that might also be a helpful episode for people.
yes.
Jeff, knowing that the initial application can often be done by the individual, is there anything they can do to really screw up their case if they try to do it on their own that first time?
Is it possible? I'm sure it's possible for them to do that. Most people won't do that. And I've not ever seen anything in the initial documents that made me concerned that they've done something that's going to have a negative impact later on. 90% of the time, what they're sending to you is what your daily activities are that you're going to fill out, a work history form that's asking you about what your job duties and what your physical requirements of your job was from the lifting, sitting, standing, etc. And then what doctors you've seen for your condition. While I might word the things a little differently than the clients do, if I'm helping them fill those forms out, I'm asking them, okay, tell me about your job, and then I will put it in there. I may word it slightly different, but it's basically information I'm getting from the clients as well that's being filled out in there, and the clients are the ones who are signing off on it, so I want to make sure it's completely accurate there. But I don't, most of the time, I don't recall ever seeing one where I read something in the initial paperwork that I thought, okay, I've got to address this or fix this problem because of what was put in there. So,
And one of the forms that they'll fill out during that time is something we've talked about before, is the form 3369, which is really that work history.
Right.
And again, if you want more details on that, friends, feel free to go back to episode 67. So with that, and I'll put links to all of these in the show notes to make it really easy for you. So Jeff, let's kind of fast forward then. So we've gone through this process. There have been some denials. There have been some requests to, hey, I want you to reconsider this. I want to keep on going. So finally, we kind of get to the hearing.
Correct.
And so this is the first time they are actually had the opportunity to be in front of the judge, and the first time you're physically going to be in front of the judge. This is that day in court. Kind of walk us through what's going to happen there.
Sure. Whenever you fill out the paperwork for a request for hearing, one of the things you're going to get shortly thereafter is you have the option of having your hearing in different ways. You can have a telephonic hearing, you can have a video conference hearing, or you can have an in-person hearing. They kind of, at least in my opinion, they want to default to a video hearing. And back when COVID was going around, actually they defaulted to telephone to start with, and then to video hearings. And before COVID, I had a policy that I didn't like video conference hearings. I wanted in person for a couple of reasons for that. It was weird the way they did it, in my opinion, but I'd have to go to the hearing site in Paducah. I wasn't sitting here in my office. I'd go over there, my client would go over there, and then the judge would be in Chicago or Macon, Georgia or somewhere, and we'd have the hearing by video conference that way. And I did that a few times, didn't like the results I was getting from that route. Kind of did some checking, and some of the judges we were getting in those had a very, very low approval rating from over what I'm used to seeing. And so I started even before COVID. I would say, no, I don't want video conference. We want in-person hearings. And then COVID hit, and we didn't have that option anymore. They would not do in-person hearings. And I had some clients that I talked with, and they said, well, we want to wait. But most could not wait that length of time from that, so they did agree to do telephonic hearings. And then even after that, we went to video, which is better, in my opinion, than telephonic hearings. But then now they've gone back to opening up for in-person hearings again, and that's my preference, is for us to have, for my clients to have an in-person hearing where the judge and my client are both in the exact same room. The majority of communication is nonverbal, and because of that, you can't pick up on any nonverbal communication by telephone. That's in my opinion, and some other attorneys may disagree, in my opinion, the worst way to attend your hearing is by telephone. If you can avoid that, I would avoid that for a Social Security hearing. The next option, as I mentioned, is video conference, and at least with a video conference hearing, the judge can see some, pick up on some of the nonverbal communications. They can see if somebody is in pain, for instance, or if someone is having a real hard time remembering because they had a brain injury and they have a memory issue and they're having a hard time remembering. Well, on the telephone, you just hear a delay, but you can't really tell that the person's trying to remember, and the judge may think, well, they're just doing this.
They're distracted.
They're just distracted, or they're not paying attention, or something of that nature. Whereas when it's video, at least they can see that the person is paying attention and the person's trying to come up with an answer, and they're having a hard time coming up with the answer from that standpoint. But even then, you're on a small screen. So you're getting basically head and shoulders, and that's all you're getting, and so you're still missing out on a good portion of the nonverbal communication, and a good portion of the things that may be the decision maker for the judge, may be the straw that tips the scales in your favor. To me, it's just much better to have an in-person hearing. To me, I have much better success with in-person hearings than I do with video or with telephonic hearings. And I've talked to other attorneys, and they seem to share that same sentiment from that standpoint, at least the ones that are more local to where they are. But I've traveled. As we've mentioned before, I'm only licensed in the state of Kentucky, but the Social Security Administration has licensed me to practice before the Social Security Administration in all 50 states. And I have had in-person hearings in several locations in Kentucky, but I've had in-person hearings in Illinois, Missouri, down in Nashville, Missouri, before, down in Georgia. I've had in-person hearings down in Georgia. Was going to have one down in Florida, and it was actually a local client who moved to Florida and wanted to keep me on the case, and I was going to go down for the in-person hearing, but luckily the judge granted it without us having to have the hearing. In that case, we're at the hearing level, but the judge granted it without us having. We got some real good evidence in, and I wrote a letter, and the judge looked at it and looked at the evidence and said, yeah, you're right, this doesn't need a hearing, and granted the case without me having to go to Florida. And it was going to be during the summertime when we were going to have the hearing, so I was okay. If it's wintertime, I probably wouldn't have wrote the letter and said, let's have the hearing. But
with that in mind, we are looking for that Hawaiian client who needs to file for Social Security disability and needs a great attorney like Jeff Roberts.
I am looking for that, or I'm fine with St. Thomas or St. Croix, either one.
Doesn't matter the time of year, right?
Doesn't matter. No, those two places doesn't matter the time of year at all. But yes, that's the. So I have in-person hearings, and if I'm representing a client out of the area, I'm still going to go with an in-person hearing because I think that's what's best for the client from that standpoint. So,
Well, there's a lot that goes on in these hearings. And back in episode 100, I love the way you laid out the 4 golden rules for testifying at your disability hearing. And that if you were getting ready for a hearing, that would be a really good episode to just kind of go through and listen to. The show notes are there, so the detailed show notes. But the nice thing about these podcasts, you can just listen to them, and you can share it with your family members or whatever. But 4 golden rules for actually testifying there at your disability hearing. So, Jeff, your strong preference then is for someone to appear in person. And in this area, that typically happens in Paducah, Kentucky. Is that right?
Paducah, Kentucky. Most of my clients are Western Kentucky, and Paducah is the hearing site for us. So that's where most of my hearings do take place from that standpoint. And, I've been in front of multiple judges in all the different jurisdictions I just mentioned, but in Paducah, I've been in front of a lot of different judges over there as well. And, when you practice in those jurisdictions a lot, you kind of learn what the judges like, what they don't like, and things of that nature. I know Paducah is a little short-staffed on judges now because they've had a couple that took the early buyout retirement thing that occurred earlier in the year. But even there, I still, I'm not really seeing any significant delay. When we first started going back to in-person, it was a little more delayed to get an in-person hearing than
Must
it
have
was.
just been a flood of requests.
I think it was flood of requests, and then you had some judges that just kind of was pushing those back because they didn't really want to do it a whole lot. But and I think there's some judges who prefer video conference hearings, and some judges who I think prefer an in-person hearing, to be honest with you. And so it took a little while to figure that out from there. But now I'm not seeing any delay in cases where I'm asking for the in-person hearing in. I had one case earlier this year that there was a slight delay because the client had one of the national companies, and they weren't happy with the representation. They come to me actually after the request for hearing was filed, and the national company wanted to do a video conference or telephone so they didn't have to fly in and go to a hearing in Paducah. And the clients come in to see me and decided to hire me and terminate the national firm that they had. I actually not sure that they were lawyers. It may have just been one of the disability consultant firms. But anyway,
and that's a big thing. I mean, people don't realize there are consultants out there that get right up to that line, and you may think, okay, I've got an attorney. You actually don't.
Yeah, you do not technically have to be an attorney to handle a Social Security disability case before the Social Security Administration. The problem comes in, and I've talked to clients about this, where they have someone who's not an attorney who handles the case up to the administrative law judge's decision. The next appeal from an administrative law judge is still at the administration. It's the appeals council, but the appeal from the appeals council is the federal district court. Well, if the person representing you is not an attorney, they cannot file that appeal to federal district court. And so that is that's where problems come in. I've had clients come in, or potential clients come in to see me, and they've been to the appeals council and got a denial, and the group that was representing them said, well, you have to go to somebody else. We can't appeal it above that. And I think a lot of attorneys are like me, and I'm not jumping into a federal court case if I didn't handle it before the administration from that standpoint. But
that's a shame, because I think a lot of people probably get caught by surprise,
Yes.
When something like that happens. And,
Yeah.
I think over all the time that would have, all the communication that would go on, all of the different, just face-to-face or via telephone or however you communicate with a client, you kind of get a really good understanding for the context behind what's going on. And as an attorney, you're going to use that at the hearing. You're going to be able to explain that at a deeper level.
Right.
And when you have to start fresh, and you're already that far down the road, it's really hard to get that back.
True. I think a lot of the ones who do that actually work for the administration in some form or fashion
yeah.
before, and are familiar with the process to some extent. But I still think that having someone who can take it to the next level, to the court level, if they have to, is something that you should have from that. But getting back to the client I was talking about earlier, when I got involved, they about the same time as my letter of rep went in, the client had gotten notified of a I can't remember if it's telephonic or video conference here, and I can't remember which one it was now. And I sat the clients down and told them. Then I said, well, I much prefer it to be in person. It may delay your case a little bit, but I think it's going to make a difference. It could make a big difference in whether it's granted or not granted. And they both, the husband and wife both said, well, we had told the other company we wanted an in-person hearing, but it didn't get conveyed to the right people or something. So I filed an objection and asked the judge to cancel that hearing and said it as an in-person, which the judge granted. And I think we were maybe 5 weeks later, so it wasn't a huge setback in the case from that standpoint. So, and actually that extra time let me get what I needed, I think, to hopefully. I'm still waiting the judge's decision in that one, but hopefully we will be successful. But it's been a couple years ago now, but I had one that just, to me, is a prime example of why you want an in-person hearing. I represented a person who had significant spinal issues. They'd had a couple of surgeries, had some permanent nerve damage, and they have a great deal of difficulty walking because of that, and they also cannot sit or stand for any length of time, hardly at all. And while, on video, my client sitting and standing frequently could be seen that they're standing. The camera's not picking up everything. And at the hearing on this case, it was clear my client was in significant pain sitting there. He stood several different times actually during the hearing, and watching him try to go from sitting to standing up and the difficulties that he had just doing that. And then when he was standing, you could notice that he was in pain. Clearly, obviously, it wasn't being faked or anything of that nature. And when he sat back down, didn't take long, 10 minutes. He had to stand back up, and like I said, it was obvious. The judge saw him walk in, saw him walk out, and when the judge was asking the vocational expert about different hypothetical sets of restrictions, the judge went with one that addressed the difficulties my client, how long it took him from going from sitting to standing and things of that nature, and difficulties he had walking. And it was a set of restrictions I'd never seen the judge ask a vocational expert before in a hearing. And the vocational expert testified that set of restrictions the person would not be able to work at all, and that happened to be it didn't happen. I think the judge, when he walked into the hearing, I don't think he had that set of restrictions written down that he was going to ask the vocational expert based on the medical records. We had sitting, standing restrictions in the medical records, but how long it took him to go from sitting to standing, like if you stand up, doesn't take, you're off task for 2 seconds, 3 seconds.
Right.
In this guy, the difficulty he was off task probably 30 seconds or more. And the judge asked that and said, it's going to take him this length of time to change position. He's going to have to do it every 15 minutes, and he's going to be off task a minute or whatever while he's changing positions. And the vocational expert said that set of restrictions would be totally disabling, and that's the set the judge went with. And I'm very comfortable that if it had not been an in-person hearing, that set of restrictions would not have been ones offered to one of the sets offered to the vocational expert that the judge ultimately went with, and it just confirmed after we walked out of the hearing, because he added that one set of restrictions that I'd never seen the judge utilize before. I had a real good feeling, and then when it come back and it had that exact set, and it convinced me then that I am correct that it needs to be an in-person hearing, that the nonverbal communication is so important in these cases. And I think that in that case there, I think the fact that we were in person probably made the difference, because this was a younger individual, so we had a harder road to hoe in that case. And I think that being in person and the judge seeing the difficulties and the pain my client was in was the deciding factor in that case.
Well, as much of these decisions, as many of these decisions are often based on obviously medical records and that type of testimony, and you had the expert witness, the expert there to testify about the vocational issues. This really also comes down to a subjective decision, and the judge is human, and when they see a client struggling like that, that has to play in.
Yes, I have clients ask me frequently what I think their chances are. And I've tried my best to give them as good of an answer, but I nearly always, if not always, tell them that any case it goes to a hearing, there's evidence the judge can use to deny the claim, there's evidence the judge can use to grant the claim, and so it could go either way. Here's the strength, here's the weaknesses, let's talk about it, and let's address how we're going to address the weaknesses at the hearing and play up the strengths at the hearing. So
yeah, no, that makes sense, and it's all. I mean, that's part of it. I mean, it's a major decision for the client that you're representing, and you want to do everything possible to make sure you're as successful as you can be.
Absolutely.
In pushing these claims forward, and congratulations on that.
Yeah.
Pretty good outcome then for the client, it sounds like.
In that case, it was a very good outcome for the client. We were successful in that case. I'm glad we were. We should have been, but it was one that
You still got to prove it.
Yeah, I still got to prove it. It was one that we could, the judge easily could have went against us in that case. We had good, strong evidence from the treating doctors. Don't get me wrong there, but I've seen clients that were as young as that client is be denied multiple times from that, and I think his presentation was 100% genuine, 100% honest, but I think the judge seeing the difficulties that this gentleman had was the ultimate deciding factor for the judge to rule in our favor. And I'll be honest with you with this, the judge is a fair judge, don't get me wrong from that, but I wouldn't doubt that he walked in to the hearing initially thinking, I don't think I'm going to be granting this guy's disability, because he's already reviewed the evidence and all of that. He hadn't heard the client's testimony, and all the judges take the client's testimony into account. They've not made a decision, but I think they have a leaning at times, and I think he was leaning toward, I'm going to deny this one, until he was in the hearing. And I think the client's presentation at the hearing is, in him seeing that in person, was ultimately the deciding factor.
Outstanding. And Jeff, we've got just a couple of minutes here left. Could you explain a little bit? You said this client was a relatively young client and had a harder road to hoe. And is there a general,
I'm a country boy.
Oh no, that's fine. That's fine. Is there a general feeling that when you're looking at a total disability decision, if you're younger, you might have a better chance of actually coming back or finding an alternate way to earn a living? Is that kind of what comes into it? Age is a factor from time to time, but
yeah, with Social Security, it's definitely a factor. Social Security treats 18 to 49 exactly the same.
okay,
The first change in the definition or the way it's looked at is at age 50. There's a break or change in the standard there, and then another change at age 55 from that standpoint. So essentially, if you're 49 or younger, then if you don't meet the listings of impairment, we have to establish that you cannot work an 8-hour day, 5-day-a-week job, that there's no, and when you're younger, And the judge doesn't look at, are there jobs out there? Are there any job openings out there for this? Is it a job that's in Western Kentucky? The judge is looking at it. Can you physically do what is considered the physical requirements of this job? And so if you can sit, stand in combination 8 hours a day, it's going to be really, really difficult to be successful in those cases. Now, there's some mental health conditions and non-physical restrictions that come into play, don't get me wrong. You can be successful in other ways, and I have been successful in other ways in those cases, but those are much more difficult cases to be successful in than a 50-year-old or someone older than 55. The standards, like I said, change. So
just kind of loosen up a little bit, basically.
well, it loosens up, and then they look at it from the standpoint of what, it's what have you done in the past, and did that provide transferable skills? Even if you can't go back to that job, does it provide transferable skills into jobs you can do and things of that nature? So, but being able, if you've done heavy manual labor your entire life and now you can do a sedentary job, well, you've never done that, and so that they take that into account at that point. They don't take that into account at 49 or younger.
Yeah, that makes a lot of sense. So, Jeff, we talked about the fact that with Social Security claims, you are licensed to handle claims and clients in all 50 states. But as it relates to Western Kentucky, you've actually got 2 offices. You're primarily officed here in Murray, Kentucky, in Calloway County, but you also have an office up in Hopkinsville.
I do, yes. I've had the office up there actually 2 years now, 2 years this month. And so I've had that office up in that location. My primary office is in Murray, Kentucky. From there, but I meet clients at the Hopkinsville location. That's by appointment only at that location. But the phone number is the same to call in to me. If you want to talk with me, you want to schedule an appointment, then you can call in to the phone number is 270-753-0053. And, that office has worked out well. It allows me, I've always had lots of clients in that area, and it allows me to meet those clients up there. And as you know, my office's motto is to provide small town service and deliver big city results. Having that office up there allows me to provide better, more personal service to my clients up in the Hopkinsville, Christian County area. And so that's one of the reasons I opened that office up. That's my motto, is to provide very good service to my clients, and having that office allows me to do that.
Outstanding. Jeff, I really appreciate the time you've devoted to prepping for this discussion today. And, just the fact that we're able to break this down, into really kind of hopefully make it a little bit more understandable. The law can be extremely complex at times, but I think these conversations really kind of help people to have a good resource to kind of get their arms around it, and ideally some of the links in the show notes to the previous episodes that might be related to the topic might also add some context. So once again, thank you as always, and we'll be back here in about 2 weeks.
Thank you.
See you, Guy. Bye-bye. Thank you for listening to the Roberts Law Office Injury Podcast. Jeff will return in 2 weeks. Until then, he invites you to visit jeffrobertslaw.com and follow his firm on Facebook. At the Roberts Law Office, you'll find a history of small town service and big city results.